All right, good morning, everybody. We'll go ahead and get started. I'm assuming everybody's audio and everything is good. So if somebody could just text in real quick, make sure everything's working. There's no computer issues. Appreciate that. Just a housekeeping reminder, if you want to ask a question, please do that through the chat function. To either Steve Moyer, who's the co-host, I'm happy to be joined with today, and either Steve or myself. So a lot of you have been through this. I am starting to recognize your emails and everything as groupies. So we appreciate your time and look forward to our hour here today. We're going to try and keep it to an hour because we just met a couple weeks ago. But there are some things that are out, and we felt like, again, it would be a good idea to get out in front of it. We're trying to do these when they make sense, not necessarily every week for the sake of hearing ourselves speak. So, okay, so if you've been through here, that's Steve and myself in better haircut days, without facial hair, I'm told, and without mask. So if you run into us on the street, we may look a little bit different here than that. So just really quick, how did we get here? Again, I've told most of you that the public is really getting to see a process it usually does not get to see. And in this case, again, really quick, tax law, they make a effective date in sometime in the future, and then they get most, if not all, the kinks tried to work them out before it becomes effective. But this, we are literally trying to build the bridge as we walk on it. And we're all familiar with the trouble with the rollout was a mess. Guidance for self-employed individuals was issued a week after they were allowed to apply. The guidance for the forgiveness was issued 3 weeks late, past their due date. And we have the taxable versus non-taxable issue going on, which we'll talk a little bit about today. And the 75-25 ratio was never in the law. That was an original SBA interpretation. So we're really going all over the place. And I know it's a little bit frustrating, but in terms of what's happening, I mean, that's what's happening. We just had a new law that was passed last Friday, 6 days ago, and we're going to advise you on that, which we were not able to advise you on before. So if it feels like your accountant's going back and forth on you, they quite may be just out of necessity. So if you see or know an accountant, just kind of take it easy on them. As well as a banker, I should bring them in too. So things are changing as we go. So here is what was passed last Friday on 5/22. This was the day after we last spoke. And the guidance was released. A couple bullet points in that guidance. Bonus and hazard pay were expressly allowed as part of compensation. Bonuses, again, my personal thought on that was, if there's a business reason for it, if it's normal operating procedure this time of year, that's fine. If not, bonuses, just kind of look a little bit beneficial with somebody else's money, if you will. So we kind of encouraged hazard pay, or just to bump up compensation to compete with Pennsylvania and the federal unemployment, if you will. So, but that was expressly in the guidance last week. This is new a little bit. The owner's salary forgiveness is capped at $15,385. That's not necessarily new. That's the $100,000 for 8 weeks. But they are also capped at 8/52 of their 2019 compensation. And so there goes a planning point. If you're an owner and you're just going to increase your salary over 2019, you can't do that any longer. We'll get a little bit more into this with the 8/52. That's just 8 weeks out of 52 weeks a year, proportionate to your original 8-week period, which, spoiler alert, is now 24, but probably everybody knows that. The other thing that came out is we're 99% certain we're 100% certain non-payroll costs can be paid or incurred during the 56-day, now 24-week period. The amounts incurred during the period can be paid by the next billing cycle. So your non-payroll costs, so your utilities or interest or whatnot, if your period ends, originally if it ended, June, what's today, June 11th. So we would have our original 8-week periods being ended right about now. So for the sake of conversation, you could take your next telephone bill or your next electric bill and prorate that to the number of days that was in your covered period at the end of the period. Again, this is 24 weeks now, so and then we'll talk a little bit about the importance of non-payroll cost as well coming up a little bit today. Again, payroll costs 99.9% must be incurred or paid. Again, both, either incurred or paid during the covered period, same as non-payroll cost. The application for forgiveness was a little bit contrary, I think, but it's in a way that, again, I feel a little comfortable saying it's incurred or paid. So one way to think about this, Steve brought to our firm, that basically says cash basis in the beginning. So if your covered period started April 20th, you cannot bring in an April 19th or 18th or anything like that. Any bills paid after April 20th, on or after, if that was the date of your funding. So cash basis at the beginning and accrual at the end. So there'll be expenses that you will physically pay after your period runs out, but you will be able to accrue them back into your period. And you'll work with your accountant on that. And then one last thing is borrowers will not be doubly penalized for reduction of FTEs and compensation. So if you reduced somebody's hours, so if you have somebody that was working 40 hours and you cut them back to 20, you were, I don't want to say at risk, but again, you would cut back on the FTEs, which again, we'll get into conversation on FTEs today, and basically the salary reduction of that person. So if you keep their base pay, so if you cut back their hours but keep their pay rate, you will not be penalized for the reduction because you didn't reduce their pay rate, you reduced their hours. So they're not going to ding you both on those. But again, with the guidance, the Flexibility Act that was signed last Friday, again, this may or may not be as big of an issue. So we do want to dive kind of right into the Flexibility Act. And with that, I will say good morning to Steve. Thank you again for joining us. And why don't you go ahead and tell us about the Flexibility Act?
All right, Brent, thank you. And thank you for that little bit of history on the past recent legislation that was, this stuff is coming out really so quickly, almost, it's hard to stay on top of it. But so Brent was just covering regulations that were just issued May the 22nd, which we had spoken to you about the last time. Just so you know, another spoiler alert ahead of time here. This won't be the last time we're talking to you because our questions that we've had in the past still are out there and have not been answered. But so May 22nd was the date of the last regulations, and then on May the 28th, the House passed their version of the Paycheck Protection Program Flexibility Act, or you can give it the initials of PPPFA. I'm not sure which one is easier to say, but maybe we'll just call it the Flexibility Act to be short. So that was passed in the House, 528. The Senate passed the same version, no changes. Actually, the House, let me step back. The House passed it 417 to 1. So it was unanimous, just about. And then the House passed their version without amendment. So they didn't change anything from the House version. That was passed on 6/4, and the president signed it on 6/5, about 11 o'clock in the morning. Usually these things come out, and that was a Friday. Usually these things come out on a Friday, but at 11 o'clock at night. So you don't have a chance to look at it before the week ends. And then you go into the weekend having to try to read these bills and summarize them. So when the bill came out on Friday, I thought, you know, I'm going to get ahead of this thing, and I had my yellow highlighter, my red pen, and my black pen that I always use when I look at new bills, so I can, you know, try to understand them. And so I went to print this bill, and I went out to the printer that's outside my office, and lo and behold, there was only 3 pages on the printer. So I'm thinking, you know, George across the hall, he always gets my pages caught up in his tax returns that he printed. So I'm thinking he's got quite a few pages in somebody's tax return. And so I'm running up and down the hall trying to find my missing pages. And anyway, there was none missing. There was only 3 pages, 3 or 4, depending on which version you print out, whether it's the PDF or the version off the internet. So anyway, it's very short, okay? And this new bill, HR 7010, modifies just the provisions related to the forgiveness of the loans under the PPP Act, under the CARES Act. So it's just modifying the forgiveness portion of the loan, okay? Most of the things that are in the bill are very favorable to most borrowers. But like I mentioned, there is still unanswered questions, and also there's additional stimulus that's already in the works. You know, I heard yesterday in the news that there are there's some bills in process to get more stimulus out to taxpayers. One of the things that you know, is a little bit, you know, just from the beginning, these programs, as Brent mentioned, were, you know, they came out so fast, they were ambiguous, the guidance came out piecemeal, so it made it difficult to plan for the forgiveness. Questions are unanswered, so it makes us rely on some common sense. And if you're familiar with tax law, many times tax law is not common sense. So you have to be able to go in and do the research and find the answers and where the nuances are. We can't do that with this bill. So we're left to relying on, common sense for a lot of our answers. And hopefully our common sense is what is going to come out in the end. But we'll, as we get through, we'll decide if that's how they came out with their answers. So the new law that changed is effective for loans. Well, it's effective for all loans, but certain things are effective for loans made after June 5th, the date of the bill. One of those is the deferral and maturity date. The deferral and maturity date of loans has been extended to 5 years, but if you had your loan previous to June 5th, you still are under the 2-year of the loan. Forgiveness, is going to be much easier, presumably, to obtain because it's now over 24 weeks. And the 75-25 for the payroll test, payroll and other expense test, is now 60-40. This also gives you an extension of time to restore your FTEs, now over the 24 weeks or till the end of December 30th, or whichever is shorter. And there's additional relief for businesses fully or partially closed through government orders. And then they also added that the deferral of payroll taxes is now available no matter if you received the forgiveness or not, which in the past you could only defer those payroll taxes until you receive forgiveness. All right. I think that's it for me, Brent, on that section.
Okay. So yeah, that slide is kind of our agenda a little bit here today. So jumping into the deferral and the maturity dates of the loan again, we all understood originally we had a 6-month deferral and then a 2-year amortization, if you will, or maturity at 1%. And that was kind of really a kicker because we were looking at a lot of companies that weren't going to be able to spend all their money and have it all forgiven. But the 18-month period that you had to pay it back really made it prohibitive. So for every $10,000, it would equate to approximately a $560 a month payment. And, if you end up with 50, 60,000, you're at $27, $28, $3,000 a month. And, that's kind of a hard pill to swallow for a lot of small businesses. So the new law, again, it allows for the deferral until the date that the lender receives the forgiveness amount from the SBA. So let's walk that through just a little bit. Obviously you'll have to apply for forgiveness. The bank will have to review it. They have 60 days to review it. Then the bank will turn it into the SBA. The SBA will have 90 days to review it and then get the answer back to you. So you don't have to make any loan payments until your forgiveness is determined, assuming that everybody is obviously going to apply for forgiveness. And there's a new due date somewhere here, maybe in the next slide or two, if I remember correctly. And a lot of the dates, the June 30th date was pushed back to December So again, there's going to be a long period here that you can play out, and for the forgiveness application and your first payment, if you're not going to have anything forgiven. But we suspect that a vast majority of businesses will now be able to have everything forgiven. And that's certainly the way it's going, and certainly the way we expect things to continue as further guidance and laws come out. So again, the actual deferral period is not certain because it depends on how fast the forgiveness application is processed. So keep in mind, though, again, this is very important, but the law is written that only loans made after the passage of the law have the new 5-year. However, right after that, the law expressly states that says, nothing in the law shall be construed to prohibit lenders and borrowers from mutually agreeing to modify the maturity terms of a covered loan. And you're probably thinking, oh, that sounds great. I'm going to pick up the phone and call my bank right after we are done here. And I just want to say, inherently, the banks aren't going to want to switch to 5-year amortization. And I think if we talk this through, we all understand it. So the bank loaned you money. So the bank loaned you $100,000. You can put your forgiveness in for $80,000, and then the SBA reimburses the bank $80,000, and that $20,000 that's left that is now the loan is the bank's money that they're collecting back. Okay, the bank isn't going to want to have loans out on the street for 5 years at 1%. So
or zero if it's a not-for-profit.
Yeah. So again, inherently, the banks are probably going to stand their ground a little bit with the contract that they do have. So just be prepared for that. And they're not going to be the bad guys in this. I know a bank I talked to yesterday said that they're not even going to take any new applications, and the application period's running out. It's still June 30th, but a lot of the volume has slowed down for applications for new loans anyway. So the banks aren't really, they do not want money out on the streets at 1% for 5 years, and we understand that. So, but if you can get it for new loan, again, that $10,000 that was $2,000 or $3,000 a month would be somewhere now around $200 a month, which is a lot easier to swallow. So here is the due date. So the big question out there that we kept getting is, when do I have to? What's the last date I can apply for forgiveness? And it basically is, and see if I can show off some skills that I've done here, but within 10 months, whoops, that's not a highlighter, that's a line. Anyway, 10 months after the last day of the covered period. So if your covered period is 24 weeks, then you have 10 months from your 24 weeks, which you're probably going to want to do. And then the bank, again, could take 60 days, and the SBA could take up to 90 days. So again, there's going to be a real period, again, that it's going to take a while for these things to be forgiven. So, okay. So Steve, you want to talk about the extension of the covered period a little bit?
Sure. So the covered period is now changed from the original 8 weeks to 24 weeks, or December 31st, 2020. I think I said December 30th before. It's December 31st, whichever comes first. So basically you have, if you're getting your loan late in the year, now just getting your loan towards the end of the period, you'd have maybe till the end of the year. But 24 weeks would be the new period. So and in the new law, there's no mention of the alternative covered period, which we just taught you about the last time around. So it doesn't look like under the 24 weeks you have that alternative covered period, but I'm not sure that it really matters. Your limits on compensation are still the same, capped at 100,000. But if we look at the $100,000 cap, in the past, when you applied for your loan, you used 850 seconds to figure out the cap for owners, or the 100,000 was 15,382. So is that now on the forgiveness? Do we have 2450 seconds, which comes out to like $46,153? And if that's the case, you can get more wages included in there for the 100,000 and the owners than you would have under the 8 weeks. The other thing you want to keep in mind is that if you got your loan prior to the 6/5 signing date, you can still elect to use the 8-week covered period, which if you were working, your employees were, your business was still operating, your employees were working, maybe that's the way to go. And we'll look at that a little bit. That's one of the decisions you're going to have to make. Do we go with the 8-week period, or do we go with the 24-week sure, almost sure thing to get all the expenses included in that? Guidance is still to come, and it could change how we look at this. So all that to say is don't run out and get that forgiveness application filed, which, by the way, the forgiveness application is going to have to change for these changes. So we can't even go ahead and get that application filed at this point. All right. Treasury did say that they were going to come out quickly and give us new guidance and give us a new application. I'm not sure what quickly means to them, but we haven't seen it yet. All right.
Yeah, just to reiterate that point, Steve, we just, again, we understand a lot of you out there manage to your 8 weeks. You're 7 weeks into it, or you've already got the 8th week or so. I think it's probably still going to be beneficial to do the 24-week period, and you'll understand that in about 4 or 5 slides here. So, try and manage to your 8-week period if you're that close. But again, you're going to, for anybody else that may be 3 weeks or 4 weeks and partially shut down or something, everybody's going to have decisions to make. But unfortunately, I know there's a lot of businesses of mine out there that really manage to that 8-week. But I think with the vast majority, we're going to do the 24-week period. So.
Right, and that's going to certainly depend on each business individually as to when they were open. Some businesses still aren't open, so they're certainly not going to be able to use the 8-week period, and that's one of the reasons for these changes, so that they weren't stuck to those limited, potential for forgiveness. Okay, so the next thing that changed in the Flexibility Act was the payroll ratios related to other expenses. So in the prior law, it was 75-25, and actually that wasn't even in the law. That was more of a SBA interpretation, and it just kind of stuck when the loan documents came out. There was a 75-25 included in the documents. So now, included in the law to receive forgiveness, you have to have 60% of costs be payroll costs. And when this bill first passed, it seemed like it was written that there was actually a cliff, meaning that if you didn't have 60% in payroll costs, that you wouldn't get any forgiveness. That was cleared up this past Monday. Both Treasury and SBA came out and said that if you fail to meet the 60% payroll costs, you can still get partial forgiveness. So that was, certainly good news for that. So it's 60-40, so 60 payroll and 40 other allowable costs. Okay, so the other thing we have to keep in mind here is that under the old law, we had 8-week covered period, and we had, we had to compare to the 2 base periods, or there was a safe harbor test that if you reduce your employees between February 15th and April 26th, and you fully restored them by the end of June, you were safe harbored, and there was no headcount reduction. You got a pretty nice gift there by restoring by 6:30. So the new law, has recognized that businesses may not even be open by 6:30 or fully ramped up. So, so the new date is December 31st. And actually, there's still some question. Is it anytime during that 24 weeks that you restore it, or is it at the end of your 24 weeks? Is it December 31st? Anyway, there's still the safe harbor in there that you will get no reduction in your FTEs if you get your full-time equivalents back up to the level where they were in that previous periods. All right. So I think there's a however there, which will take us on to the next slide.
Okay. So yeah, I'm happy to cover that, Steve. Really quickly, I don't have any questions. I think we have a pretty smart audience today, I guess. So do you have anything, Steve?
I don't have any questions at this point.
Yeah, I do have people that text or chat it that they hear me, so I guess we're left with that smart audience today. So either that or we're talking to two people, I guess. So as Steve said here real quick, again, the original law had an FTE that you had to maintain through your covered period. And we all understood that. And the reason, part of the reason that this new law, the Flexibility Act, is so short is only 3 pages. It says, strike this date, insert this date, strike this, insert this. So it wasn't describing a whole new law. It was just saying strike and insert. And, you know, I came in Monday morning looking at this and you know, something kind of hit me. And I had some conversations Monday with some clients, but you know, 9 times out of 10 when something hits me, like most of the men here, I think it's probably my wife with pretty good cause here. And the 10th time something hits me, I'm usually wrong. But I ended up being right on this in that the FTE calc you had to maintain through your 8-week period. Now the law technically reads that you have to maintain your FTE calc through the 24-week period. And the reality is people can't do that. You know, the business is down, you know, we're not fully ramped back up. And this to me was kind of a major issue, you know, in that people were so happy with the 24-week period, they were, you know, ignoring this issue on the back end that the FTEs now have to be maintained during the 24-week period. So as the week went on, you know, a couple people kind of addressed it and did confirm, you know, in the webinars that I was in and sat in. But this is really important. And honestly, for the three sessions we've done, these next 2 slides are going to probably be the most important to understand here. So the law is written that the loan forgiveness shall be reduced by your FTE count calculation. However, the application for forgiveness that did come out that's now obsolete is a reduction. The FTE reduction is applied to cost versus the forgivable amount. And you'll see that in this next slide, but that is really important, okay? So now you have 24 weeks instead of 8 weeks to run up cost, right? Which is great. You're gonna have a lot more cost to throw in here, hopefully. Your borrowing was still limited to roughly 10 weeks on borrowing capacity. So if we are applying the FTE to 24 weeks of cost, it seems like we should be able to take a FTE reduction, a substantial one, and it's not going to hurt us until, you know, we get down into an equivalent of a 10-week range, right? So it seems now that we can somewhat afford a significant FTE reduction for those that were having people on payroll only for forgiveness that aren't really working. Okay, it seems like we can now revisit that with this new law. So, but the question is the revised application going to keep that same structure? Because again, as I had just said, the original law was written differently. So here, if you're familiar with it, and we'll have to go through here quick, Steve, because we got to keep the pace if we're going to try and make an hour. But the forgiveness amount was either your loan amount, and you needed to check your 75-25% ratio, or this modified total. And it says forgiveness amount, enter the smallest of 8, 9, or 10. Well, 9 is your loan amount, 10 is checking your 75% payroll. Well, what's 8? 8 is multiply 6 by 7. There's your FTE reduction to get to line 8. And basically line 6 then is add the amounts on 1 through 4, which are your payroll costs, your mortgage interest, your rent, lease, utility payments. So you basically add all them up. We're ignoring the salary reduction right now. But you add your cost up, then take your FTE reduction to get a modified total. So if you borrowed 100,000, but you have 300,000 now of cost or 400,000 of cost, and you still have an FTE reduction of half, you're going to get that full forgiveness if the application is drafted the same way. If I'm a betting person, I think it'll probably be drafted the same way. But you know, the problem is nowhere in the law did it say that your FTE reduction should be applied against utility payments, rent or lease payments or interest. So it's one of those things, either a government employee is going to find it, or we might luck out a little bit, and that's what they meant to do. So there you go. If I was a business, you know, I think I would go with the 24-week cost, make sure I have cost, and then, you know, take the FTE and assume that the application is going to be the same here. So,
hey, Brent.
Yep, go ahead.
Brent, just to point out, there the 75-25. Previously, there was two 75-25 rules. One was for your payroll and non-payroll costs, and the other 75-25 rule was for the reduction in your payroll to employees.
Yep.
That one still remains. That 75-25 percentage is still valid.
Yeah, yeah. Most of this law is still in effect, and again, you know, it's just making there. It was a very short law, 4 pages, you know, so not a lot of quantity has changed, but it drastic impact here. So, so in this new law, the Flexibility Act, again, Steve sort of mentioned if you restored by 6/30 in the old law, you could get the forgiveness. That 6/30 date is pushed back to December 31st, all right? And if a borrower experiences a loss of FTEs, you can not be subject to that reduction if you're able to document there was an inability to rehire individuals and you could not find similarly qualified individuals, okay? Or there was an inability to return to work at the same level due to compliance with government requirements and guidance. So if they have you shut down right now, you know, you're not going to suffer the FTE calculation right now. All right, so there's some questions about this yet, but clearly the direction that they're going is trying to reduce the FTE penalties, if you will. And then one last thing that was in the law.
Brent, that last one on that previous, inability to return to the same level of business activity. That's a pretty broad, I'm losing the word here, but area of, you know, it's going to be maybe fairly easy for a lot of businesses to not return to the same level because of you know, regulations and all that were imposed on them. So anyway, I think that could be area where many businesses can fall into that FTE exclusion or
Yeah, and Steve, one other thing is kind of caught me is all these are federal government, but I'm pretty sure they're going to view it as if the state government is enacting based on federal government guidance, that would qualify.
right.
Yeah. Okay. I'm not sure, again, that's the way it's technically written, but it's the way I'm sure it's going to be interpreted. So, okay. And then last, Lynn, this is what you emailed me on last night, but in this new law, the old law allowed you to defer the 6.2% employer share of Social Security taxes until the date of forgiveness. But the new law now expressly allows the deferral through December 31st, regardless of when forgiveness is granted. And again, this is available for everybody. It's available for self-employed, for partnerships with payroll, partners that have guaranteed payments, corporations on your payroll. Basically, you know, if you want a interest-free loan, then the government is giving this to you, that you can withhold your 6.2% employer share, not the employees, and then pay whatever you don't remit through December of 2020. 50% is payable in 2021, and the other is 50% in 2022. So it's an interest-free loan. I don't have a whole lot of clients that are doing this yet. A lot of people just have the incentive that they want to pay as they go. But this is available. If cash does start to get tight, you can enter this and do this at any time. But it will be, there's no requirements in terms of receipts or being opened or closed or anything like that. This is just available to everybody now at any time. All right. Steve, if I can have you go from here, I did, I guess, invite questions, so I'll look them over while you're taking the next couple slides here.
Okay. Yeah, so some of the things that weren't included in with the Flexibility Act, you know, which we were hoping for maybe some answers to, but again, it was a very short bill, probably one of the shortest, you know, I've ever seen come out in the 35 years that I've been doing this. So the IRS came out and said that the deductibility of expenses paid with PPP loans were not going to be, well, they weren't going to be deductible, which is, you know, contrary to what we originally thought when this program was enacted back with the CARES Act. So we're still hoping that there's going to be something that comes out through Congress on this that makes those expenses deductible. That's also maybe one of the reasons why we just need to, you know, push off filing for the forgiveness and wait and see what happens. There was nothing in there for the enhancement of the employer retention credit, which you can't take the retention credit when you have the PPP loan funds. And then there was some talk of some items to help certain nonprofits and smaller businesses with fewer than 10 employees. I think that was mentioned in the last presentation that we had. Nothing came through specifically on that. So, you know, those weren't included. We still have, you know, as we've been saying, and pretty much all along in every one of these presentations that we've done, that there's still questions that need to be answered. We don't have all the answers. We don't have all the guidance. So some of those things that still remain are the definition of an owner is, are all S Corp shareholders? Are they owners? Is there a percentage limit on your ownership of S Corp stock to make you an owner? The cap on the compensation, the 100,000, which we mentioned, is that the 24 50 seconds under the new law now, or is that still 8 50 seconds? The 15,000 originally, or can we now put in costs of 46,000 over the 24 weeks? Self-employed individuals, are they now 24 50 seconds? Because when they filed for their loans, we use the 8 50 seconds, and then the forgiveness was based on the 8 50 seconds. Can the borrowers, if they're using the 24-week period, can they apply any time during that 8 and 24 weeks? So maybe at the 16-week, they hit all their numbers, and we know that they're going to have 100% forgiveness. Can they apply at that point, or do they have to wait till the end of the 24 weeks? We don't know that. We mentioned this, the next item also, FTEs, can they be restored at any point prior to 12/31, or do you have to wait till 12/31? There's a lot of logistics. We mentioned already the forgiveness application is going to need to be changed, but what about all the loan contracts that previously went out and had the 75/25 in there? Do all those contracts need to be changed? So there's a lot of questions that are still up in the air that we don't have answers to. Legislation, as I mentioned earlier, there's talk about new legislation, new forms of stimulus, because actually the government's not sure how things are going to go with the economy just opening up. I heard this morning, there's another 1.5 million that have new applications for unemployment. So, we got some good news last week, but is that going to turn around? There's new hot spots with the COVID cases, with businesses opening up. So what are they going to, what's going to be needed to get the economy back on track? I mentioned the deductibility of the expenses paid with the forgiveness amount of the loan. Guidance, forgiveness application, we talked about, we need a new application. Or is there going to be 2 applications, one for the 8-week period, one for the 24? I don't know that. We don't know that. We're going to need to see what happens there. Planning, things to consider. Certainly, and I know Brent has mentioned this before, we don't want forgiveness to be the main focus. We want to make sure that your businesses are viable and that you can sustain keeping your business going. That's what we really want for everybody out there. So what we now have with the 24 weeks is not, everybody doesn't need to, keep their payroll levels up. If you're paying somebody just to get forgiveness, you probably want to consider stopping and making sure that your business is going to be able to, if you're just opening back up or not even opening, you want to be able to make sure that you have the cash in reserves and only use the funds that you got for the PPP. Maybe use those for the other expenses that are allowable, until you can get your business back up on its proper footing. Timing of forgiveness and tax year, until you get forgiveness, what you have is you have a loan on your books. So is that loan going to affect your ratios with your bank and the other loans that you have with them? So maybe in certain cases, you might need to try to get the forgiveness done earlier so that you don't have that outstanding loan on your books. Or, maybe we push it to the following year and wait to see what the IRS comes out with the deductibility of expenses. So all that to say is we don't have to rush now to make these decisions. We have time to stop, and you have time to come and talk to us to help, make some of these business decisions and do the forecasts and projections to make sure that you're going to be in good, footing. Your foundation is strong going forward so that you can keep your business going. I think that's really, like I said earlier, we know we're going to be coming back again because we don't have all the answers. We know there's going to be probably new law coming on the books at some point, maybe later in the summer, but in the meantime, don't hesitate to, reach out for any questions that you have to us, and we'll, help you through the situations as best we can.
All right, Steve, thanks. It's 11 o'clock. If I can take one more minute of everybody's time. Steve and I are happy to do these. Like we said, we're going to be back again when applications come out or whatever. So we've done 2 hour-and-a-half ones. That's 3 hours. Today was an hour. So that's 4 between the two of us, at least 8 man hours, and then preparation. You're getting some good time. So I think we've reached a point of our relationship where I could probably ask you for a 5-minute favor. And if you wouldn't mind, we would really appreciate it. I would really appreciate it if we could go on Google and leave a Google review for Cannon Capital, especially our clients. If you're new, you can certainly leave a review as well. And, LinkedIn and Facebook as well. There'll be links in the email that follow up. Again, we'll make this recording available on our website and go from there. But I would just really appreciate 5 minutes of your time at this point. I do have some questions here, Steve. So if you wouldn't mind sticking around, and we'll go through them. And, anybody that has to leave because it's 11, so be it. But I think we'll try and take a quick scroll through these questions. So if you submitted one, you might want to hang out here just a little bit. Steve, do you have any?
I don't have any on mine, Brent, so go ahead.
They're getting smarter by the week. Okay. Scott here, wanted to find out if they determined that the PPP forgiven amounts are in the end not taxable. So Scott, again, we covered this. Right now, the way the law is written is they are taxable. They're not deductible expenses that are paid with the PPP funds, which in essence, backdoor makes the PPP loan forgiveness taxable. They are working. I suspect we'll hopefully see some movement on that. Steve, would you concur?
I do believe that's the case. That wasn't the intent, I don't believe, of Congress when they wrote this. They wanted it to be a tax-free a loan, which it is. You know, it's written that way. The loan is not taxable, but the IRS then came out with their interpretation and their regulations and made the expenses not deductible. So I do believe that will get changed, whether it's by an act of Congress or the IRS coming out and changing their rules. I'm not sure which one.
And even if, let's say the nuclear scenario, even if it remains the way it is now, understand, Scott, that the taxability of the forgiveness is the least draining cash flow scenario, if you will, versus going out and getting outside financing and having to pay all that back. Again, you're just going to pay taxes on it, but you're going to have the forgiveness, if you will, money that you don't have to pay back. So hopefully you can, absorb that a little bit, but, again, we expect to see movement on that. Lynn asked if we have a spreadsheet available for calculating the loan forgiveness based on what we know now. Very simply, the answer is no, because we have to wait for that revised application. Stephanie will take that offline. Jerry asked, and Steve I might need your input on this. We are an overseas church planting agency. Most of our staff not qualifying for the PPP loan. When calculating the FTE, do I include those staff or only the staff I can use for forgiveness? The employees had to be U.S. citizens, right? In America, working here.
Yeah, I think that would be one of the issues, that it has to be U.S. It was in the original PPP information, the original
law.
Yeah, you have to be U.S. So I'm not sure. I mean, I know what the question is that some of those are probably being treated as subcontractors and not employees per se. So technically, if they are getting a 1099 and they file a Schedule C, then they would have to apply for a PPP loan on their own and not through the organization.
Yeah, and I think the easy answer is, technically what you used on the way in to apply, you should be using on the way out. I don't know that U.S. citizen has tweaked or anything like that in any of these interpretations or guidance. Linda Amorosi asked, can I use 100% payroll for the 24-week period for forgiveness and not use any utilities? Yes, Linda, we should have stressed, and I sort of meant to. So now that you're up at 24 weeks, you have all those additional costs, not the least of which is payroll. All the rent's easy enough, but all the utilities and all the interest and whatever else, all the little nitpicky type of expenses, the pressure has really come off that to use, or to get them documented and used. You may not even need them depending on your payroll. So yes, payroll can account for 100% of your cost, and you may not need anything else. And certainly going up to 24 weeks makes that much more of a reality.
Yeah, and certainly if you have any of those, like in the previous sessions, we were trying to define what was a utility cost, what was, can your 2019 retirement plan contribution count if it was paid in your period. So some of those questions may have gone by the wayside with the longer period, that you can include those costs that we know for sure are includable and not have to worry about any of those questionable costs that we were so worried about in the past.
All right, a couple more, and try and knock off at around 11:10, but Chris asked, when we use our loan proceeds up, so the loan proceeds are going to be gone after 10 weeks, can we then lay off extra workers that we cannot use since our work level did not come back? Will we still be able to have 100% forgiven? And Chris, yes, that I think is pretty much what we're saying is, if you had employees that are not technically, theoretically working, but you're only driving for forgiveness, I think I would lay those employees off now that we have the 24 weeks. Lisa asked, the PPP Schedule A is the cash compensation gross pay. Would the buy for 56-day period from the date of the loan? Lisa, again, the application's going to change. So if you have some question on the compensation or something, I think the question's a little bit deeper than the application. If it's application driven, then I would say just wait. But if you want to shoot me an email, Lisa, maybe we could have a little more in depth of a conversation. Sharon asked, what if your physical year ends June 30th? I can't think of anything that would affect, Steve. Can you?
No, I don't think if you have a fiscal year doesn't really change what your covered period would be. Again, your covered period starts when you get the loan, and it's either 8 weeks or 24 weeks from that time, unless you get your loan late and then it's December 31st is the last. I'm just thinking of something else, Brent. I don't know that we mentioned it, but yeah, the new loans, there is still money out there.
Yep.
And they are theoretically available until June the 30th. That would be the last loan date. So if there's still somebody out there that hasn't gotten a loan, you want to get your application done rather quickly.
All right, Steve, I think that's it on this end. If we didn't get to something, feel free to email us and we'll be happy to get back to you. Otherwise, again, when another one of these makes sense, we'll reach out and go here again. So thank you, everybody, for your time. Hopefully it was worth it, and we'll talk to you down the road.
Yes, thank you. Have a great day, everybody. Bye.